Good morning. My name is Daniel Hunt, and I am the lead attorney here at the law offices of Daniel Hunt. And what we wanted to do with these videos is provide some educational tools for people who may come to our website and want to learn more about estate planning, wills, trusts. With these videos, the hope is that we can answer questions that we commonly get here at our law firm, and with answering those, help people out so that they might be able to make a more informed decision on their estate plan, whether it be putting together a trust, whether it be filing a conservatorship, whether it be contesting a trust, any of these things. It's always nice to have clients who are informed. So with the first video in this series that we're going to try and post once a week, and it may not always be me. I'd like to have other staff members come in here and speak as well, so you're not always having to listen to me. But today, a question that we get frequently is, what is the difference between a will and a trust? We get that question a lot. So a will is a person's official declaration in writing as to what they want to have happen with their estate when they die. A trust, on the other hand, is a legal arrangement whereby you place assets into a trust with a trustee who manages those through a fiduciary relationship for the benefit of somebody else or even themselves. So it's really a legal arrangement of holding assets for the benefit of someone. Whereas a will is only activated at someone's death, and it only controls assets that are in your estate. So there was a case that came out, what was this, in February, that would help kind of explain maybe the difference between a will and a trust. And this was Wilkin v. Nelson. And in this one, you had a husband and wife had separate property, and she wanted to leave that property to her sons from a previous marriage. So she went to an attorney. The attorney drafted a trust, and she put two properties into this trust. Also, this attorney had her sign a will that in the clauses, the distribution clause, the residue clause, it said it left the residue of her estate to her sons as well. So this created a big problem because that was not her actual intent when she signed that will. Her intent in doing this estate plan, putting this trust together, was to leave properties to her sons. Her intent was not to leave all of her estate to her sons. But because she had a will that controls estate assets, it was ambiguous as to what really that will said. So was it that she really wanted all of her community and separate property to go to her sons? No. The facts show that she only wanted her separate property to go to her sons. But she had this will that was controlling things that said she wanted her community and separate property to go to them. So it turned into a lawsuit between her surviving husband and her two sons from a previous marriage. Surviving husband was able to show facts saying that this will was in fact wrong. It was not a reflection of her intent. All of her community property, she wanted it to go to me. And so you have to be careful when you're using a will and a trust, because a will controls estate assets. A trust typically just controls the assets that are placed in it. So our clients, almost all of them, have both, where they'll have a will and a trust. The assets being controlled mainly by the trust, and the will just catching anything, a pour-over will, just catching anything that's left outside of it. So that hopefully helps explain the difference between a will that's just a catch-all for anything that's left outside of a trust, and a trust that you actually put assets into, that controls while you're alive, but only controls trust assets. So hopefully that's helpful, and you learned a lot today about the difference between wills and trusts. Thanks.